was super helpful in getting us, these guys to come up and chat with you guys about some of a little more about the law side of where you're at in your life. So they're going to talk to you guys about estate planning and elder law and some of those things. So super excited to have them here, and I'm going to let them take it away as soon as I get this PowerPoint up and going here. All right, that's fine.
Thank you, Nate, and thank you to the Fishers YMCA for the opportunity to talk with you all today. My name is Thomas Vick. I am an elder law attorney. My office is in Greenwood, so a little bit of a drive here to Fishers this morning or this afternoon, but great to be with you. My friend Seth Wilson, who I do a podcast with called the Lifetime Legacy Lawyer Podcast, is with me today, so appreciate him being here as well. The topic for today is, what is elder law? Elder law is let me get the presentation mode going here. There we go. Elder law is a growing field, especially as baby boomers are starting to get into their 70s and 80s. And elder law is really about the issues, the legal issues that older people have. There's no real one topic that could describe elder law. So it can span, all these different kinds of areas. It can deal with estate planning, and we're going to be talking about estate planning today. So wills and trusts, powers of attorney, that kind of thing. But then also alternative decision making and Medicaid and Medicare, and how those two government programs can intersect, and what Medicare covers and what Medicaid doesn't cover. That's where an elder law attorney can really bring some insight into an individual's life. Social security disability, special needs planning, veterans benefits. All of those are topics that kind of fall under the heading of elder law topics. And today we're going to be talking about long-term care planning, and then also some estate planning. So those are the main topics that we're going to be discussing today, and kind of how to plan for long-term care expenses. So if you were to kind of observe me in my office and kind of figure out what I would be doing, on a typical day, I might be talking to a family that has just been to the bank, and the bank has said, your parent, I understand, is going through a hard time, but you don't have a power of attorney in place, and so we don't have legal authority to be able to talk to you about your loved one's financial situation. And so they're kind of stuck, and they arrive at the conclusion that you need to talk to an elder law attorney. And then I'll be talking to that family about a guardianship and what all is required by the court to get a guardianship open, so that a loved one has the legal authority to be able to make decisions for the loved one. So that might be an example of somebody that comes and talks to me. Another example of somebody that might come to talk to me is a loved one has gone into the hospital, and maybe it's a stroke that has occurred, and then after a period of hospitalization, the loved one has gone into a rehab facility and has been there for about 2 or 3 weeks, and a social worker at the nursing home or the rehab facility says that we think that your loved one has some needs that need more care, more time here in the facility, but Medicare is not going to be covering the cost of this rehab facility. We need to transition your loved one to a long-term care facility or a 24/7 nursing home facility. Medicare is not going to cover it, and it's really expensive, so you probably need to talk to an elder law attorney about how to get your loved one onto Medicaid. That's another kind of situation that I talk about with folks on a regular basis. Another one is, maybe a married couple that comes into the office and they're perfectly healthy, their family's healthy, everything's good, but they understand that long-term care is expensive, And we want to kind of plan for that and protect as much in the way of assets that we can. And so they might come and talk to me about how to protect their house from having to be sold if one of them gets sick and needs care. So those are just 3 examples that are pretty common in my practice, and they can really, and we'll kind of talk about those scenarios as we go through today. But I wanted to kind of give you a little bit of insight into what I do on a regular basis. So long-term care planning, I don't know that anybody can see what the definition is because of the fine print, but long-term care is dealing with a functional impairment in carrying out activities of daily living. And activities of daily living really are not medical in nature, but it's like helping out somebody with bathing or dressing or toileting. You know, we don't really like to think about those things, but as we age, as our loved ones age, those become realities for us. And if we need care, we got to find a way how to get the care. And so that's what elder law attorneys help individuals do. Here are some examples of events that would lead to long-term care situations. So maybe you have an immediate event like a heart attack or a stroke, maybe a personal injury accident. That could lead a family into an elder law attorney's office. Or it might be kind of the gradual decline where we see that mom or dad is struggling with some memory loss, dementia, or Alzheimer's. They're fine for a while after the diagnosis, but things progressively get worse. Or maybe just old age and getting frailer. Those are also situations where an elder law attorney can come and help plan for long-term care. Will you need long-term care? Here are just 2 or 3 facts about long-term care that indicate there's a significant likelihood that all of us will need long-term care at some point. If you are 65 years of age or older, there is a 70% chance that you'll need long-term care of some kind at some point in your life. So 70% is the chance that all of us at some point are going to need long-term care. Women tend to need it longer than men. Women just live longer, and so I think that's why they need it longer. They average needing long-term care for 3.7 years, and then for men, it's 2.2 years. So if you need long-term care, the chances are that you're going to have to need it for a long period of time. I guess that's why they call it long-term care. 33% of today's 65-year-olds may never need long-term care. So on the other hand, there's a decent chance that you might need it, but 20% of those that do need long-term care need it for 5 years or more. So there's a 20% chance that it could be 5 years or longer. So again, a significant chance that we'll all need long-term care at some point. Why plan for long-term care? The reason is it's expensive. Here are some stats that I pulled in preparation for the seminar today from a company called Genworth. According to Genworth, a home health aide costs $80,000 per year. Adult day health care costs $72,000 a year. Assisted living facilities cost on average $47,000 a year. And for a nursing home facility in a semi-private room, it costs $94,000 a year. And then for a private room, it's $123,000. And that's for the Indianapolis area. So those are numbers that are not nationwide, but specific for the Indianapolis, Indiana area. It's expensive, and so thought should be given as to how to plan for long-term care expenses. Beyond just the financial reasons to plan for long-term care, there's also these sort of personal reasons why you should plan for long-term care. First of all, to retain control and determine who is going to be the one that's going to help you make decisions if you need somebody to make decisions for you. If you don't have a plan, then somebody, whether it's a court or somebody else, is going to make those decisions for you. So you can kind of bring things under your control by going ahead and coming up with a plan for long-term care. Another reason is to protect your spouse. You know, a lot of folks come into my office and they say, I don't really care what happens to me, but if something happens to me, I want to make sure that my spouse is protected, that they have what they need. So that might be a reason to do long-term care planning. And then to preserve an inheritance to children or grandchildren or whoever you want your beneficiaries to be. Making a plan in advance can give you more of a likelihood of protecting those assets and them being there for your loved ones. So what are some planning strategies? And again, I've been talking here for a little while, but if there's something that I say and you kind of have a question about it, feel free to raise your hand and we'll answer your question. So feel free to participate here. Some planning strategies. The first one is sort of an obvious one and didn't take a lot of thought for me to put it in there. Private pay. You just pay the bill and just eat it, so to speak. That may be a way that you do it, and you just pay until the well runs dry. That's one route to go, and there's no shame in doing that. Another one is long-term care insurance. Long-term care insurance is an option, and if you bought a long-term care insurance policy in the 80s or 90s, it's probably fantastic. But as long-term care has become more and more of a pressing need, it's become more and more of a, just too expensive for anybody to really purchase. And so that may be an option, but again, maybe not an option. There's sort of a compromise of long-term care insurance policies and life insurance policies called hybrid policies. Now you can purchase what's sort of like an insurance policy, sort of like an annuity, but you can also use it with a rider on those policies so that you can kind of dip into the cash value of that policy and use it for your long-term care needs. So if you need somebody to come and help you at home, you can use a hybrid annuity to be able to, kind of finance privately a way for somebody to come and help you at home. So that's an option that's becoming more and more popular in the long-term care field. Another one is VA aid and attendance. For the veterans out there, there's a program that if you are a wartime veteran and if you meet certain asset and income limitations, then you can get the VA to help you pay for your long-term care expenses or your unreimbursed medical expenses. And interestingly, one of the unreimbursed medical expenses that is covered by VA aid and attendance is for somebody to come and help you at home. So you could pay a loved one with a personal service contract, and the VA will kind of help you to pay that person. Or you could use the aid and attendance pension to pay for an assisted living facility. And that's what a lot of veterans do. They use the VA aid and attendance program to kind of supplement whatever pension or Social Security that they might have, kind of gives them a little bit of a boost so that they can pay for their assisted living costs. And then you can plan for Medicaid taking care of your long-term care expenses. There are really two different kinds of Medicaid programs for long-term care. One is sort of what we think about with Medicaid for the nursing home. It's under the Medicaid for the Aged and Disabled program. That's administered by the Indiana Family and Social Services Administration. And then there's also the Medicaid waiver program. The Medicaid waiver program has many of the same financial requirements of Medicaid for the nursing home, but the big difference is you get to stay at your home or in an assisted living facility, and Medicaid will help you finance that, will help you to be able to pay for your long-term care in those situations. For a lot of the time today, I'm going to be talking about Medicaid and some sort of the planning strategies that can be used to get you eligible for Medicaid. There are strict financial requirements, and we'll talk about those, but through an elder law attorney can walk you or your loved ones through how to protect as much in the way of assets that you can. So for the Medicaid waiver program, like I said, you have to be eligible for Medicaid under the usual financial requirements. But it offers services at home, and on this slide I listed some of the services that are provided. I mentioned assisted living, adult day services, adult family care, attendant care, actually home modifications. I think the Medicaid waiver program will allow up to $15,000 of home modifications if you're in that program. Homemaker services, home delivered meals. So there are a lot of benefits that come along with the Medicaid waiver program that can help individuals. So for Medicaid, the financial requirements are kind of as follows. You got two different tests. One is the resource test, meaning your assets, what kind of property do you own, but then also what kind of income do you have each month? You know, do you have a Social Security check coming in? Do you have a pension check coming in? Do you have some other form of income? Maybe you're still working. All of those things go into play when we're talking about the income test. But to be eligible for Medicaid, you have to be under $2,829 per month of income. That's the test. And you say, well, I've got a pension and I've got Social Security and I have more than $3,000 of monthly income. There's no way that I could be eligible for Medicaid. Well, that's not true. You have the ability to establish what's called a Miller Trust. And it's really just a legal fiction, as we call it. You just put your income into this trust that's set up with a bank, and then from there you spend the money however Medicaid directs you to, and then Medicaid says, okay, you met the income test. So it says that you got to be under $2,800 or so, but if you're not, then we got an exception for you, and you can take advantage of that. So that's one thing that I help clients with, is establishing a Miller Trust and kind of talking through the rules with them. And I won't bore you today with all the details of the Miller Trust rules, but just know that if you got $3,000 or more of income, that doesn't mean that you are not able to get on Medicaid. And then the resource test. So if you're a single person, not married, and you have more than $2,000, Medicaid says that you're rich and you can take care of your own long-term care expenses. So congratulations, you're rich. You might have $2,500 in the bank. Medicaid won't cover. And so the strategies that we come up with as elder law attorneys is, how do we get down under $2,000 of assets while also doing some gifting or purchasing some resources that are not going to be countable resources. How can I kind of pass on my savings onto my children, because I want to make sure that they have something when I pass on. That's sort of how I help clients. If it's a married couple and both are needing long-term care services and they're applying for Medicaid, then it's just $3,000. But there are some planning opportunities if there is just one spouse that needs care and the other spouse is healthy. There is actually a lot of ways that we can help protect nearly everything that the married couple owns together through the healthy spouse. And here are some of the rules about that. If there's a healthy spouse and a sick spouse, there are special resource rules that allow the healthy spouse to keep more than that $2,000 or $3,000. It's actually about 50% up to a certain level. So if the married couple owns approximately $300,000, they get to keep about $150,000 through the healthy spouse. Then if you have $60,000 or less of countable resources, then the healthy spouse gets to keep about $30,000. And in between, it's about 50% that you're able to keep. And so we counsel, couples or adult children that are helping out their parents. How do I take advantage of keeping, 50% with the healthy spouse, and then what do I do with the other 50%? What are accountable resources for Medicaid purposes? It's really anything that you got control and access to. That's the Medicaid rule. But some of the categories of accountable resources include cash that's in the bank, and also cash that you have under the couch. Joint bank accounts typically are considered accountable resources. Retirement accounts are accountable resources, and this is sort of an update that I haven't been able to tell a group of people until today, and it's not really a great rule. There is a regulation that is being considered by Indiana FSSA that will probably go into effect in August of this year, that says that both the healthy spouse's retirement account, let's say IRA, and the sick spouse's IRA are accountable resources. As of today, the healthy spouse's IRA is not considered accountable resource, but FSSA is going to be making a change come August. In all likelihood, that's going to say that both spouses' qualified retirement accounts are considered in the analysis of accountable resources. And so that's going to be a big change for the elder law field in Indiana, because we've been able to do a lot of protection for clients through the healthy spouse's IRA. Stocks and bonds, those are considered accountable resources, and life insurance with cash value is also considered a accountable resource. And that trips people up all the time, because many people, probably some in this room, have a life insurance policy that has some cash value. It may be a $10,000, $15,000, $20,000, $25,000 policy, pretty affordable, but over the years it has built up, and maybe it's got $10,000 of cash value, and it's there for the purpose of paying for the funeral, making sure that the kids have a way of paying for the funeral when the parent passes away. But that $10,000 of cash value in the life insurance policy is actually an accountable resource, and you've got to get rid of it some way, somehow, in order to get down under that resource limit, $2,000 or whatever the case might be. And so those are some accountable resources. That's certainly not an exhaustive list, but yeah. Yes, sir.
Do you have on there the spouse's IRA account, the healthy spouse IRA?
Yes.
Is it accountable?
Yes. The question is to talk a little bit more about the healthy spouse's IRA account. And as of right now, if a husband is in the nursing home and is applying for Medicaid, and the wife is healthy, living at home, doing everything that she normally does, but she has an IRA that, say, has $150,000 in it, that healthy spouse's IRA is not considered in this analysis. It's safe. It's protected. But there's going to be a change in all likelihood in August of this year that's going to make that not the rule anymore. And that IRA of $150,000 held by the healthy spouse is going to be an accountable resource. And so that is going to have to be dealt with in getting the sick spouse, the husband, onto Medicaid. Does that answer your question?
I don't know. Well, the question was, in my mind,
The way to screw you, that's the whole thing.
the healthy spouse, if I were to be sick, my IRA account would not be accountable now?
Correct.
But in August, it will be accountable?
Yes, in August.
If I get sick before now, this August,
Yes.
still IRA account's not count.
Yeah, so those that are applying for
Why are they
Med,
changing that?
they're changing it because it's too good, I suppose. It's too good. Yeah.
I mean, it's a 50-50 crap show, whether or not, who's healthy?
Yeah, it is. That is definitely a change that's happening. Indiana FSSA has been in the news recently for a lot of the, being under budget. I think $1 billion or something like that, due to their long-term care program, Medicaid waiver, and so they're making some changes. But that change itself has been discussed for several years, but it seems like 2024 is the year that they're likely to implement it.
So how can we plan for this when they change the rules all the time?
Well, you're talking to me right now. Talking to me right
Well,
now.
I went till August.
Yeah.
That's not long.
Yeah. So exempt transfers, these are transfers that you can make without penalty. And so wanted to kind of talk about those. Adequate consideration, so if you go and you buy a vehicle, that's for adequate consideration. That's not a penalizable transfer. Indiana FSSA is not going to be penalizing you for doing kind of your normal thing. And by penalizable transfer, I mean if you were to give away, $100,000, and then you have a long-term care event, and all of a sudden you need to have that paid for, you have to report any transfers you made for less than fair market value within the last 5 years. And $100,000, that's going to require you to pay for your care for about 13 months. And so you got to be very careful about what kind of transfers or gifting you do without the advice of legal counsel. I'll do gifting with folks, but it's with a very specific calculation in mind. Yes, ma'am.
Okay, when this new law goes into effect, you think that some people will go ahead and get a divorce so they can save their money, so they have something going on?
Actually, that's very true, yes. And that's actually one type of planning that's done currently. You might not have to go and get a divorce, but you could get a legal separation, and which, for all intents and purposes, seems like a divorce. But then after the money is transferred or whatever, you can dismiss the legal separation and be back to married again. That is a tool that elder law attorneys can use, but certainly one that I do not like using. But that's sort of the question that is brought up by these rules. A couple other exempt transfers. Anything to the spouse is considered exempt. So it might be that the house is listed in husband and wife's name. Husband is sick. Let's transfer the husband's interest in the house over to the wife so that the house doesn't get caught up in any kind of Medicaid estate recovery, and the house can just be the spouse's. To a disabled child is an exempt transfer. To a trust for a disabled person under the age of 65 is an exempt transfer. So you're not going to get penalized for it. So these are, if somebody has these conditions in the family, we can plan through protecting the asset through these folks with these conditions. And then transfers that are beyond 5 years. So I'll be talking a little bit about the house and how you can protect that. But it's with the idea of having enough time, 5 years, to be able to make it to safety, so to speak. Everybody asks about the house. How do I protect the house? So-and-so, a friend of mine, their mother went into the nursing home and they had to sell the house. How do I prevent that from happening? Well, here is the rule. The house is exempt as long as there is a spouse living there, minor children, or an adult child that's disabled, or blind children. So as long as there's somebody with those conditions living at the Medicaid applicant's house, then the house is exempt and it's not countable, so it's not going to that $2,000 threshold. But if not, if there's nobody living at the house anymore, no spouse is there anymore, then Medicaid will say, you got to put that house up for sale or rent. And then you've got to use the proceeds of that sale on your care. So that's not the best result. And so it's good while the spouse is, the healthy spouse is living at home, but when that healthy spouse gets sick, that's when the teeth of Medicaid, if you will, really take hold. And that's where I counsel clients about a Medicaid asset protection trust. So this is sort of a hybrid trust where we can put the house and other real estate, maybe some savings if you wanted to put savings into it. Put these into a trust where you name usually an adult child as the trustee, so you kind of trust that person to do what you want them to do. But they hold it in trust for you, and you retain a right to continue to live in the house, and you can even retain a right to receive any income that you have on the investments if you wanted to do that. But it separates you from your asset just enough that Medicaid won't count it as a countable resource. It's not an available resource. So that, if 5 years from now you need care, you don't have to report that as a countable resource. You just have to report the other assets that you might have. And so that's a fantastic way of being able to plan for long-term care expenses, because in many families, the most valuable asset that the family has is the principal residence. And so using this Medicaid Asset Protection Trust can be a tool to kind of at least limit the amount of expense that's going to go into long-term care expenses. Like I said, the trustee can be a relative or a friend, and you do this with the idea of having at least 5 years to be able to make it to safety. But the way that I design my Medicaid Asset Protection Trust, there is a backup plan in place if long-term care is needed before 5 years is over. Yes, sir. Yes.
Is that what the Miller Trust is?
No, sir. It's a different. The question was: is the Medicaid Asset Protection Trust the same thing as a Miller Trust? It's a good question. It's a different trust. It's a different trust. The Miller Trust is one that you would use when you are applying for Medicaid. The Medicaid Asset Protection Trust is done for pre-planning, where there's not a current, immediate need for long-term care. I do want to talk about Medicaid estate recovery. I think it was maybe 2018 that the Indiana Code was amended to require personal representatives or executors of estates to notify Indiana Medicaid Estate Recovery that there's now an open estate for a decedent if that decedent is age 55 or older. So any estate where the decedent was age 55 or older, the attorney or the personal representative for the estate has to tell Indiana Medicaid Estate Recovery, if you have a claim, this is your opportunity to do so. It's a requirement under the Indiana Probate Code. And so there, I talked to Indiana FSSA and, give a client social security number, and they have to the dollar and cent how much money was spent on that individual's care. And they'll file a claim in the estate, and they won't release that claim until they're paid off. And so that's a huge reason why it's very important to avoid probate. And we'll talk about some ways to do that. But Medicaid Estate Recovery is active here in Indiana, and they will. There are a few exceptions. So when there's a married couple, and let's say this husband, he's having a hard time today. This husband passed away, and he's survived by the spouse. They're not going to, Indiana FSSA, Indiana Medicaid Estate Recovery is not going to make a claim on the husband's estate. But when that surviving spouse passes away, then they will file a claim in the estate for both the husband's and the wife's potential Medicaid Estate Recovery claim. So again, it's really important to avoid Medicaid Estate Recovery if we can by avoiding probate. I still have more information about estate planning and all that kind of stuff, but I kind of took quite a bit of time with Medicaid itself. Are there any questions about Medicaid that I didn't cover in that first part? Here in the next 5 minutes or so, I'll kind of go through ways of doing estate planning. some of these ideas may be very familiar to you, so it might be kind of a review, but they're important to what I do every day. So estate planning really deals with what's the best way to pass assets to your beneficiary. And your estate really deals with whatever you own, the house, bank accounts, all that kind of stuff. Probate is the process by which you will petition the court to get authority to kind of settle a person's estate. And that's a way to avoid, it's the process that we really want to avoid because it's a public process. When a personal representative is appointed, then you've got to put creditors on notice, including Medicaid estate recovery, and then you've got to wait a period of time before which you can be released from those claims, if you will. So ways to avoid probate. A revocable trust is one way to do so. Another way is by doing that Medicaid Asset Protection Trust, and then doing transfer on death deeds. That's a simple way of doing it, but you can do a deed that says that you're the owner of the house as long as you're living, but then upon your death, it transfers on death to maybe your kids, and that avoids any kind of Medicaid or avoids any kind of probate estate. I caution clients often not to just name an adult child on their bank account, especially when that's not the only child that they have. Because when an adult child is a joint owner, that joint owner is an owner and can take that money out at any point in time, and then upon your death, that money is legally the adult child's and it's not their siblings. And there may be some rule, some understanding that that adult child is going to provide that, the adult siblings with, the money, but there's no legal requirement. Another one that I caution people on is just adding an adult child onto the deed of the house. And that's, cautionary for a couple of reasons. One is the one that I just said. The house would be legally the adult child's and it won't be anybody else's. And so you're just leaving it up to the whims and goodwill of that adult child to actually carry out your wishes. But another reason is because there's taxation that likely is involved if that's not the principal residence of the adult child. So when that adult child goes to sell it, they're going to probably have to pay capital gains taxes. So there are a couple reasons to avoid that kind of planning. A revocable trust is a good way of doing estate planning. This is where you and, if you're married, your spouse can be co-trustees on the trust, or just, if you're not married, just single, you'll be the only trustee. But then you can have successor trustees, so that while you're, if you're incapacitated at some point, your successor trustee can just come and fill your shoes and continue to manage your affairs. But then beyond incapacity and beyond death, that successor trustee can also handle your affairs. That's one advantage of a trust over a power of attorney, because a power of attorney that authority ends at death, but then a trust can continue beyond death. It's private, so you're not going to have to put all the world on notice about there being a trust, and it avoids probate, so you're going to avoid that Medicaid estate recovery process in all likelihood. A last will and testament, this is the document that says where you want your assets to go. If you have minor kids, you can name who you want to serve as guardian of your minor kids if you were to predecease. And I think we're probably familiar with a last will and testament. Special needs trust planning, if there's an individual that is in your family that has special needs, maybe is already on Medicaid or Social Security or Supplemental Security Income, SSI, the Social Security Administration, a special needs trust should be set up so that that beneficiary receives the benefit of receiving something from you, but then also doesn't lose government benefits that are means tested. So that's one way to plan for that individual. A durable financial power of attorney, these are for financial decisions during incapacity, but you can also make them such that they are immediately in force, and you can immediately authorize your loved one to begin making decisions for you. Healthcare Advance Directive is for healthcare decisions, and it's important to have a HIPAA authorization within that advance directive so that your loved ones can talk to the doctors, the nurses about your situation. These can be immediately effective or upon incapacity as well. A living will is the document that states your preference as to end-of-life decisions. And that's kind of the sum of that. So what estate planning documents should you have at minimum? I recommend that everybody has a last will and testament, a durable financial power of attorney, advance directive, a HIPAA authorization, and a living will. But then also, I strongly recommend that people consider having a revocable trust to avoid that probate process. Medicaid asset protection trust planning if avoiding, protecting the house or something like that is important. Maybe a farm, a Medicaid asset protection trust can be used for that. And then a special needs trust, like I just mentioned. I wanted to do a couple little advertisements. Seth Wilson here of Adler Attorneys in Noblesville does a podcast with me called the Lifetime Legacy Lawyer Podcast. We've got, you can find us on YouTube. We've got several videos on there, or you can just Google Lifetime Legacy Lawyer Podcast, and you can find us there. Then also I wanted to let you know that I have a blog digest or an e-newsletter that goes out each week on Fridays that has some information about estate planning and elder law. I've got a sign-up sheet up here if you're interested and want to receive more information about elder law and you don't really want to come talk to an attorney but you're kind of interested. That would be a good way of kind of learning some more information. I also have a link to the Lifetime Legacy Lawyer podcast on my blog digest, so you'll see a recent episode of the podcast if you get the newsletter. So again, I've got a sign-up sheet up here if you're interested in that. I gave you some materials about what is an elder law attorney. If you wanted to talk to me further about some kind of issue that you've got, there's a way to contact me on some of the handouts. You're welcome to do so. I'll be around for a little bit longer, so if you want to come talk to me after this event, you're welcome to do so. Yes, sir.
We went to our bank and had our children listed as beneficiaries on the account when we die.
Yes.
Put that up, how we wanted the kids to get it, the money's in the bank account. So we think that's going to avoid probate and everything.
Yes.
Walk into the bank with a death certificate, prove their ID and say, I want mom and dad's money. Is that correct?
Yes, doing a paid-on-death account, that sounds like what you did there at the bank. That's a great way of avoiding probate. Yeah. Yes, ma'am.
What do they charge nowadays for elder attorney?
Well, it just kind of depends on how complicated it is. So with my Medicaid Asset Protection Trust plan, I charge about $6,000 for the revocable trust and the Medicaid Asset Protection Trust. And my philosophy with that is let's say we put the house into the Asset Protection Trust, but then we don't put the bank accounts into there because we need access to those accounts. We should put those into some form of trust so that we're not leaving ourselves hanging by not having everything in the trust, and then eventually there would have to be a probate estate. And a revocable trust is better than a transfer on death account because it can plan for contingencies. It can say if an adult child passes away, it should go to my adult kid or the grandkids, but at a certain age 25 and maybe 35. Or it can plan for divorce or creditor protection, that kind of thing. And so I usually recommend that it's best to have both, an asset protection trust and a revocable trust. As far as a Medicaid application is concerned, it's really determined by how much complexity there is to it. Yes, sir. You found out that there was an advertisement on TV and the financial company didn't have license? No. I'm not a financial representative, I'm an attorney. Yeah, you gotta be careful and use trusted sources, and that's actually where an elder law attorney can help you. And I've had experience with certain financial advisors that are good and can steer clients in the right direction, and not just financial advisors, but maybe a health insurance guy or facilities that have treated my clients well. I can kind of help clients go in the right direction. Yes, ma'am.
Do TODs avoid probate?
Yes, ma'am. TODs avoid probate. Yes. Any other questions? Well, I appreciate very much your attention, and again, thank you to the YMCA for the opportunity to come and speak to you today. And like I said, I'll be around for a little while after this. Thank you.